I understand I have 15 minutes to basically talk about what is quite different from the kinds of issues that we've heard by the previous speakers. In that, I suppose you could summarize those various issues by saying that we've looked at regulation so far and how existing sort of regulatory structures and corporate laws, etc., allow for a certain amount of sustainable development progression, hopefully. This presentation is really very different. It starts from the premise that when we think about sustainable development, and I zoom in specifically on climate issues, that unfortunately we need an everything in the kitchen sink approach. We need to throw everything at this that we can possibly throw at it. That includes indeed regulatory action, but it certainly also includes litigation. So what I'm about to tell you is some aspects of private international law on how climate litigation specifically might further sustainable development issues. You will get these slides, I think, in some sort of a way. So hopefully that will be useful for those of you perhaps less familiar with private international law. Now, I won't talk about all the things on all these slides. I'll probably run through a number of most important issues. What you see on this particular slide is simply an overview of the kinds of claims that you could get in climate litigation. And as you can see, indeed, there's a wide variety of categories. The one that we are interested in most, excuse me, at the moment, sorry, for this particular panel, is the third bullet point here, and probably also the fourth, so the duty of care, as well as the investor suits, and I will talk about those in a minute. Now, you may have seen from the title, what I basically want to explore is to what degree a corporation could use forum shopping, but also applicable law shopping when trying to divert climate litigation. But of course, as a flip side of the coin, it also means, of course, that claimants, in the wide variety of claimants that present themselves in climate litigation, that claimants as well, of course, will be making use of forum shopping and applicable law shopping. So for those of you unfamiliar with private international law, otherwise known as conflict of laws, just a quick reminder that it involves 3 steps: jurisdiction, which court can hear a claim; applicable law, what law will that court apply; and finally, recognition and enforcement. How can I get my hopefully attractive judgment enforced in a different jurisdiction? When you think about forum shopping, clearly there's a number of things that you might want to take into account. One of them, obviously, is that you might want to try and sue in a jurisdiction that seems to be happier than others to engage with the various claims that are being brought forward in climate litigation suits. Obviously, the Netherlands is a destination of choice, seeing as Dutch judges at the moment have taken a very, how should I put this? I was going to say proactive, but that sounds almost activist. Certainly, the Dutch judges seem to be unfazed by the suggestion that when they issue judgments that impose climate obligations on governments or on undertakings, that these are somehow revolutionary or indeed go past the role that a judge should perform, right? Dutch judges are not at all impressed by that, as opposed to other judges. And you see, by the way, that this theme of the judge being more than just a mouthpiece of the law, the judge somehow putting himself or herself in the in the place of policymakers, is obviously a very strong theme when it comes to climate litigation. And there's certainly a huge amount of judges that, as a result, very reluctantly do much at all when it comes to climate litigation. I've got a few examples there, but there's, of course, many more. One particular aspect, of course, also of forum shopping is the financial aspect, including cost orders, etc. Again, I don't talk about that today, but it's something to bear in mind. There would certainly be a huge amount of jurisdictions where the cost implications are a very strong deterrent to suing, and there's other issues like SLAPS, etc. But these are not so much at issue this afternoon. One interesting element here, also because of the example I will give you later of the Client Earth and Shell case is the question of recognition and enforcement. So quite a few climate suits, unfortunately, will be fairly straightforward tort suits where someone has suffered damage, and people having suffered damage from floods, etc. in Australia would be a straightforward example of this. And there'll be many, many more of those in the future where people have a straightforward tortious claim and therefore also a money judgment that may have to be enforced in a different jurisdiction. If a corporation is happy to suffer the reputational damage from not abiding by such judgments, and of course there are many corporations that do not have immediate contact with consumers that might be happy to do so, mining corporations, big chemical manufacturers, etc., then indeed there are many ways in which they can string out such a recognition and enforcement step for very many years. And Chevron is the most notorious case when it comes to dragging out procedures over decades. But there's also an interesting and highly intensive debate at the moment, which is what if you have a non-pecuniary order? The Milieudefensie and Shell case in the Netherlands is an obvious example of this. So the judge ordering Shell to develop climate plans for all its operations worldwide. That subsequently needs to be enforced, of course. And Shell, in the meantime, have moved headquarters. They used to be dual listed in the Netherlands and the UK. Now they're single listed in the UK. If and when Shell were to refuse to abide by the order and/or the claimant suggests that the compliance by Shell is under par, then of course there will have to be an English judge intervening in how this Dutch order is going to be imposed. That's not so straightforward. Also because it involves foreign public law, which judges generally, when it comes to recognition and enforcement, are very reluctant to do. So that's something to I think really think about. Also, by the way, outside of the completely international context, if you purely think of national climate litigation, there's an obvious question: what if a judge orders a party to do something, including a government? How does the judge then second guess whether or not that party has done this properly when it comes to a non-money judgment? Not an easy proposition. Now, the interesting element that I wanted to focus a little bit on as well today is applicable law. So as I suggested, once you have a judge hearing the case, it is certainly not routine or not always the case that a judge will be applying their own laws. And of course, that's something which applicants hopefully tend to know very well. There are many ways in which you can suggest to a judge that they should be applying a law that is different from the law of their own jurisdiction. Now, when it comes to climate litigation, most, but not all, most of those claims will be tortious claims, for which the applicable law differs across jurisdictions. Australia very famously has struggled with this and continues to struggle with this through a somewhat complicated application of the lex loci delicti commissi. I apologize for the Latin, for those of you not familiar with Latin. So the law of the place where the delict was committed. That used to be the case under English law. Now in English law, including and also in European law, the general rule tends to be the lex loci damni, the law of the place where the damage occurred. The downside of that is that it puts quite a bit of onus on the claimant, because if you start from the point of view that it's the law of the place where the damage occurs, then of course in climate litigation, you may as a claimant have to prove, particularly in a common law court, you may have to prove a whole myriad of applicable laws, which of course can be a great obstacle towards having a successful claim. I should point out, by the way, that the UK, despite Brexit, still applies the main applicable law regulations which they have retained from EU law. Of course, they might change that in the future, but the mood certainly amongst practitioners and judges is that hopefully government will not be changing that, because that would lead to a much less predictable approach, both in contract and in non-contractual claims. And the law indeed, which that retained law is this regulation that you see here, the Rome II regulation that determines applicable law for non-contractual claims. The one article that jumps out when it comes to climate litigation is this Article 7. It's the only article in the whole of EU and now also English and Welsh applicable law, which has very much a value-driven approach. It gives the claimant the choice to ask the judge to apply either the law of the place where the damage occurred, if that is interesting to the claimant, although as I just flagged, that might lead to a myriad of applicable laws, or the law of the place where the event giving rise to the damage occurred, which certainly in a climate context, you could argue is probably the place of the corporate headquarters, because that's where decisions are being made to engage or not properly with climate issues. This Article 7 is for that reason very, very interesting. Now, there is not necessarily the case, by the way, that these should all be non-contractual claims. There are certainly also contractual claims. There are claims in insurance issues. There are other headings of Rome 2 that could be relevant, including unjust enrichment, etc. Basically, whatever interesting law the claimant will be able to identify, they will try and make their way towards suggesting to the judge that this law naturally applies. That's a mechanism called reverse engineering. Of course, as a practitioner, you do not do the academic exercise of working through regulations and case law and then somehow academically ending up with an applicable law. You do the exact opposite. You know, hopefully, which law is the one that you would like to apply, and then you work your way back in statute and case law to convince the judge that logically this law indeed is the applicable law. What I want to focus on this particular slide is the last, well, I've already mentioned here, the last bullet point of the holding policy, but the open question that I want to just spend a few minutes on, and this I think is actually my one but last slide, which the chair will be pleased about looking at timing, which is the question indeed whether the corporate duty of care somehow is covered by what is called the Lex Societatis carve-out. So in applicable law, the applicable law will say that there is no discussion at all and you cannot go applicable law shopping whatsoever if the matter belongs to what is called the sort of natural realm of the corporate law, typically of the place of incorporation. That, of course, is attractive to corporations if they then incorporate in jurisdictions where they hope and believe that that law is indeed attractive to them for these kinds of activists' lawsuits. Now, it is probably not the case that a claim brought by an individual who alleges to have been harmed by lack of climate action or indeed some general sustainability action of a corporation is included in this carve-out. And there's a Court of Justice judgment that is relevant for these purposes, which concerned a Dutch insolvency suit classified as a tort suit. There are, of course, exceptions, including for cases involving directors' liability. And here, I suspect many of you will be familiar with the Client Earth derivative suit, which was checked out by the High Court a couple of months ago. So this is a derivative suit where the judge was not at all convinced, first of all, and this was an interesting element from a private international law point of view. Client Earth argued, amongst others, precisely linked to what I suggested earlier about enforcing foreign orders. They said, look, the directors of Shell, most of them resident in the United Kingdom, will at some point have to enforce this Dutch order. And we suggest that there is such a duty upon them to do this. Justice Strauer, however, suggested on the basis of authority clearly that there is no such duty when it comes to foreign court orders. That's quite a, how should I put this, quite an archaic point of view, I think, in English authority when it comes to modern private international law, and it very much clashes with this idea of mutual trust, which exists not just within European member states, but also across international jurisdiction. The second bullet point here is more linked to evidence issues on climate change management, which was very disappointing, I think, finding of the judge there. But then finally also, the judge suggesting in the light of the de minimis extent of Client Earth's shareholder interest in Shell, because of course they'd only procured a very limited amount of shares, that he suspected that there was an ulterior motive to their claim, rather than one which could be linked as in the derivative interest. There is certainly an awful lot of room for forum shopping here, because if you look comparatively at how derivative suits work across the globe, then there certainly would be corporate laws that would be much more attractive for claimants, I think, to bring that claim. But again, in turn, that means that corporations might want to move out of such jurisdictions if they fear that there would be too much of these lawsuits held against them. That concludes my thoughts here.